In episode 2 of the Supreme Court Opinions Read podcast, I will be reading the Supreme Court's opinion in Bouarfa versus Mayorkas. The case was decided December 10th, 2024. And as always, we will start with the syllabus. Amina Bouarfa, a U.S. citizen, began the process of obtaining permanent legal residence for Allah Hamayel, her non-citizen spouse, by filing a visa petition with the U.S. Citizenship and Immigration Services. Relevant here, USCIS shall approve a visa petition if it determines that the facts stated in the petition are true and that the non-citizen is the petitioner's spouse. 8 U.S.C. Section 1154b. But if the non-citizen has previously sought or received an immigration benefit by reason of a marriage determined by the Attorney General to have been entered into for the purpose of evading the immigration laws, known as the Sham marriage bar, the agency must deny the petition, Section 1154c. USCIS initially approved Bouarfa's visa petition. 2 years later, the agency sent Bouarfa a notice of intent to revoke its approval based on evidence suggesting that her husband had previously entered into a marriage for the purpose of evading immigration laws. Although Bouarfa vigorously denied the evidence, the agency revoked its prior approval based on the Secretary of Homeland Security's statutory authority under Section 1155 to revoke the approval of any petition for good and sufficient cause. The Board of Immigration Appeals affirmed the revocation, finding that USCIS's determination that Hamayel had entered into a prior sham marriage that would have prevented initial approval of the petition under Section 1154c constituted good and sufficient cause for the revocation under Section 1155. Bouarfa challenged the agency's revocation in federal court. The district court dismissed the suit, holding that Section 1252A2B2, a provision that strips federal courts of jurisdiction to review certain discretionary agency decisions, barred judicial review of the agency's revocation. The 11th Circuit affirmed. Held. Revocation of an approved visa petition under Section 1155 based on a sham marriage determination by the Secretary is the kind of discretionary decision that falls within the purview of Section 1252A2B2, which strips federal courts of jurisdiction to review certain actions in the discretion of the agency. Part A. Section 1155 is a quintessential grant of discretion. The Secretary may revoke a previously approved visa petition at any time for what the Secretary deems good and sufficient cause. Such a broad grant of authority fairly exudes deference to the Secretary and is similar to other statutes held to commit a decision to agency discretion. Congress did not impose specific criteria or conditions limiting this authority, nor did it prescribe how or when the Secretary must act. Context reinforces the discretionary nature of Section 1155. Section 1252A2B2's neighboring provision, Section 1252A2B1, bars judicial review under specific provisions, each of which contains language indicating that the decisions involved are entrusted to the discretion of the Attorney General. Section 1155 contains similar language. Part B. Bouarfa argues that although some revocations are discretionary, the revocation here was not, so Section 1252A2B2 does not apply to preclude judicial review. Bouarfa contends that once the Secretary approves a petition and later determines that the beneficiary had previously entered into a sham marriage, the Secretary has no choice but to revoke the agency's approval. Neither the statutory text nor its context limits the Secretary's discretion this way. Section 1. Contrary to Bouarfa's argument, Section 1154C's text nowhere creates an ongoing duty for the agency to continually confirm that its initial approval was sound. Instead, Section 1154C's command to the agency extends only to the point of approval. Turning to Section 1154C's context, Bouarfa argues that because a non-citizen may use an approved visa petition to continue along the path towards permanent residency, Congress implicitly required the agency to continually reassess its prior approval. But nothing in the statutory scheme requires revisiting past decisions of approval, Rather, each stage of the process comes with its own criteria. Indeed, the specific grant of discretion in Section 1155 to revoke prior approval of a visa petition forecloses the argument that Congress silently mandated revocation in certain situations. Section 2. Bouarfa's assertion that the Secretary always revokes the agency's approvals of a visa petition if the agency later makes a sham marriage determination makes no difference because Congress did not make the availability of judicial review dependent on agency practice. Rather, Section 1252A2B2 bars judicial review of decisions made discretionary by legislation. Nor is it unreasonable to suggest that Congress created a system in which a sham marriage determination is subject to judicial review when an agency denies a visa petition, but not when the agency revokes a prior approval. That distinction reflects Congress's choice to provide reduced procedural protections for discretionary relief. Section 3. Precedent, likewise, does not mandate Bouarfa's interpretation. Unlike the discretionary determination at issue in Patel v. Garland, Section 1155's revocation authorization has no threshold requirements to access the relevant discretion. So Patel does not help Bouarfa. Finally, because the presumption that administrative action is subject to judicial review may be overcome by clear and convincing evidence of congressional intent to preclude judicial review, there is no need to resort to the presumption of reviewability where, as here, the statute is clear. Now on to the opinion. Justice Jackson delivered the opinion of a unanimous court. The common feature of our nation's complex system of lawful immigration is mandatory statutory rules paired with discretionary exceptions. Executive branch agencies implement both. Whether any given agency decision is mandatory or discretionary matters because Congress has limited judicial reviews of many discretionary determinations. See 8 U.S.C. Section 1252A2B. This case involves the Secretary of Homeland Security's decision to revoke initial approval of a visa petition that Amina Bouarfa, a U.S. citizen, filed on behalf of her non-citizen spouse. The Secretary points to 8 U.S.C. Section 1155 as the source of the agency's revocation authority. That provision states that the Secretary may, at any time, revoke approval of a visa petition for what he deems to be good and sufficient cause. The issue we address today is whether revocation under Section 1155 qualifies as a decision in the discretion of the Secretary, such that it falls within the purview of a separate statute, Section 1252A2B2, that strips federal courts of jurisdiction to review certain discretionary actions. We hold that it does. Part 1, Section A. The agency decision at issue in this case occurs along the pathway to permanent legal status for a non-citizen spouse of a U.S. citizen. There is no dispute about the steps involved. A U.S. citizen kicks off the process by filing an immigrant visa petition on behalf of her spouse with the U.S. Citizenship and Immigration Services, which exercises authority delegated by the Attorney General and Secretary of Homeland Security, Section 1154A. If USCIS approves the petition, the non-citizen may then apply for an immigrant visa to enter the country as a lawful permanent resident, or if he is already in the country, for the adjustment of status. USCIS's decision to approve or deny a visa petition filed on behalf of a non-citizen spouse involves a number of mandatory determinations. For instance, if the agency determines that the facts stated in the petition are true and that the non-citizen is the petitioner's spouse, it shall approve the petition. Section 1154B. However, as relevant here, there is also a mandatory exception. If the non-citizen has previously been accorded or sought to be accorded an immigration benefit by reason of a marriage determined by the Attorney General to have been entered into for the purpose of evading the immigration laws, the agency must deny the petition. Section 1154C. This is known as the sham marriage bar, and although we have never held as much, the parties agree that judicial review under the Administrative Procedures Act is available to challenge the agency's invocation of it. See, for example, Mendoza versus Secretary, Department of Homeland Security, and Ruiz versus Mukasey. The visa petition approval process for non-citizen spouses of U.S. citizens can also involve certain non-mandatory determinations that Congress has authorized agency officials to make. One such statutory provision is at issue here. It broadly states that the Secretary may, at any time, for what he deems to be good and sufficient cause, revoke the approval of any petition. Section 1155. Footnote 1. In a separate provision, Congress has limited the reasons why the Secretary may revoke the approval of a visa petition for some petitioners. See 8 U.S.C. Section 1154H. That provision does not limit the Secretary's discretion to revoke based on a sham marriage determination and is therefore not relevant here. We took this case to determine whether the Secretary's decision under Section 1155 to revoke the agency's approval of a visa petition based on a sham marriage determination is the kind of discretionary decision that falls within Section 1252A2B2, a jurisdiction stripping provision. As noted above, in the immigration realm, properly identifying the mandatory or discretionary nature of a particular agency decision can be critical precisely because that status has implications for whether the agency's decision can be challenged in court. Through Section 1252A2B, Congress stripped federal courts of jurisdiction to review two categories of discretionary agency decisions. First, Congress precluded review of any judgment regarding the granting of relief under 5 listed statutory provisions that empower the Attorney General to grant certain relief to non-citizens, Section 1252A2B1. Second, in the provision at issue here, Congress barred review of any other decision or action of the Attorney General or the Secretary of Homeland Security, the authority for which is specified under this subchapter to be in the discretion of the Attorney General or the Secretary. Section 1252A2B2. Footnote 2. In certain contexts, Congress has restored judicial review over constitutional claims or questions of law, Section 1252A2D. The parties agree that this case does not implicate that provision. Section B. Amina Bouarfa is a U.S. citizen who married Alaa Hamayel, a non-citizen and Palestinian national. They have 3 young children, all of whom are U.S. citizens. A few years after they married, Bouarfa filed a visa petition on Hamayel's behalf. USCIS initially approved the petition, but 2 years later, the agency sent Bouarfa a notice of intent to revoke its approval. The agency informed Bouarfa that it had uncovered evidence suggesting that nearly a decade earlier, her husband had entered into a marriage for the purpose of evading immigration laws. According to the agency, during an interrogation, Hamayel's ex-wife had stated that her marriage with Hamayel had been fraudulent and that she had asked him for $5,000 before filing a visa petition on his behalf. The agency told Bouarfa that, had it been aware of this evidence at the time it reviewed her visa petition, it never would have approved it. Bouarfa vigorously denied these characterizations. She pointed out that her husband's ex-wife had later recanted her statements, claiming that she had made them under duress. Nonetheless, USCIS concluded that there was substantial and probative evidence to support a finding that Hamayel's prior marriage was for the purpose of conveying immigration benefits. Recognizing that the Secretary was permitted to revoke the approval of any petition for good and sufficient cause, the agency decided to revoke approval of the visa petition that Bouarfa had filed on her husband's behalf. Bouarfa appealed that revocation to the Board of Immigration Appeals, which affirmed. The board explained that USCIS had revoked its approval because it determined that the visa petition was approved in error in light of 1154C's sham marriage bar. On de novo review, the board concluded that the evidence supported USCIS's determination that Hamayel had entered into a sham marriage. The fact that such a determination would have prevented the agency from approving the petition in the first instance, the board found, constituted good and sufficient cause for revocation. Having struck out before the agency, Bouarfa turned to the courts. She filed an APA action in federal district court, arguing that the agency's revocation was arbitrary and capricious, an abuse of discretion, and not in accordance with law, because the agency lacked sufficient evidence to support its sham marriage determination. The district court granted the government's motion to dismiss, holding that Section 1252A2B2, a jurisdiction stripping provision, barred judicial review of the agency's revocation. In Bouarfa v. Secretary, Department of Homeland Security, the 11th Circuit affirmed. It concluded that the text of Section 1155 makes clear that the Secretary's authority to revoke the approval of a petition is discretionary. In the court's view, it made no difference that the agency rested its revocation on a determination that would have required the agency to deny the petition in the first instance. Nothing in the statute, the court reasoned, requires the Secretary to revoke the approval of a petition in any circumstance, even when the department later determines that the approval was in error. We granted certiorari to resolve a question that has split the courts of appeals: whether federal district courts have jurisdiction to review the Secretary's revocation of the agency's prior approval of a visa petition. Footnote 3. Two circuits have held that federal district courts may review challenges to the Secretary's revocation in at least some situations. A number of other circuits have come out the other way. Bouarfa challenges the Secretary's revocation on the assumption that the fact that her husband is not in removal proceedings does not affect the jurisdictional analysis. Footnote 4. We therefore assume, without deciding, that Section 1252A2B applies when, as here, a non-citizen is neither in removal proceedings nor seeking review of a final order of removal. Part 2, Section A. It is clear on the face of Section 1155 that the revocation provision is a quintessential grant of discretion to the Secretary. Once again, that provision provides that the Secretary may, at any time, for what he deems to be good and sufficient cause, revoke the approval of any visa petition. Section 1155. As this court has repeatedly observed, the word may clearly connotes discretion. Moreover, here, Congress has in no way prescribed how that discretion must be exercised. There are no conditions that the Secretary must satisfy before he can revoke the agency's approval. He may do so at any time, for whatever reason he deems to be good and sufficient cause. That broad grant of authority fairly exudes deference to the Secretary and is similar to other statutes that we have held commit a decision to agency discretion. Context reinforces what the text makes plain. Section 1252A2B2's neighboring provision, Section 1252A2B1, bars judicial review of determinations under 5 statutory provisions that address different forms of discretionary relief from removal. Each of these provisions contains language indicating that the decision is entrusted to the Attorney General's discretion. See, for example, Section 1229BA and Section 1229CA1. Section 1155 contains similar language. Indeed, many of the undoubtedly discretionary provisions listed in Section 1252A2B1 vest less discretion in the Attorney General than Section 1155 vests in the Secretary. The Attorney General may, for instance, cancel removal for a permanent resident only if he determines that the non-citizen has been a lawful permanent resident for at least 5 years, has continually resided in the United States for at least 7 years, and has not been convicted of an aggravated felony, Section 1229BA. He may exercise his discretion to waive the consequences of a fraud determination that would otherwise bar relief only if failing to do so would result in extreme hardship to the non-citizen's family members or, in certain situations, the non-citizen. Section 1182I1. And he has discretion to adjust a non-citizen's status only if he first confirms that certain preconditions have been satisfied, Section 1255A. When it comes to the Secretary's discretion to revoke the agency's approval of a visa petition, though, Congress imposed no such threshold requirements. If the provisions listed in Section 1252A2B1 pertain to discretionary agency determinations, surely Section 1155 does too. That discretion is a two-way street. By granting the Secretary discretion to revoke the agency's approval of visa petitions, Congress has also vested the Secretary with discretion to decline to revoke an approval the agency previously gave. So, if the Secretary determines that the agency's approval of a visa petition was erroneous, he can revoke that approval, or he can let the error stand. As a general matter, then, this discretion may work to the benefit of visa petition beneficiaries, since rather than tying the agency's hands by forcing revocation, Congress created room for mercy. In any event, when the Secretary opts to revoke a petition that he determines should not have been approved in the first place, the petitioner is not out of options. As the government concedes, nothing prohibits a citizen from filing another petition on behalf of the same relative. Indeed, Bouarfa has already taken advantage of that alternative here. After the Secretary revoked the agency's approval for her petition, Bouarfa filed another one. That petition is still pending, and if it is denied due to the agency's sham marriage determination, Bouarfa can seek judicial review of that determination. Section B. Bouarfa disputes hardly any of this. She concedes that some revocations are discretionary for purposes of Section 1252A2B2, but she argues that this particular revocation was not. In Bouarfa's view, if the Secretary approves a visa petition and later determines that the beneficiary had previously entered into a sham marriage, the Secretary has no choice but to revoke the agency's approval. We cannot agree. Nothing in the statute's text or context limits the Secretary's discretion in this way. Subsection 1. Bouarfa's textual argument rests on Section 1154C, which she argues creates an ongoing duty for the agency to continually confirm that its prior approval was sound. Section 1154C commands that no petition shall be approved if the Attorney General makes a sham marriage determination. According to Bouarfa, we should interpret this provision as directing that no petition shall be approved or remain approved if a sham marriage determination is made. The problem for Bouarfa's argument is that Section 1154C nowhere suggests that its command extends beyond the point of approval. Nothing in the provision mentions revocation, and we need not guess in what situations Congress wanted the Secretary to revoke the agency's approval, because Congress answered that question directly. The Secretary may do so whenever he deems there to be good and sufficient cause, Section 1155. This specific grant of discretion to revoke forecloses the argument that Congress silently mandated revocation in certain situations. Turning to context, Bouarfa argues that because a non-citizen may use an approved visa petition to continue along the path towards lawful permanent residency, Congress implicitly required the agency to continually reassess whether its prior approval was in error. But nothing about the statutory scheme requires the agency to revisit past decisions. Instead, each stage of the process comes with its own criteria. See, for example, Section 1255 and Section 1182. Of course, if the Secretary determines at any point along the way that the agency's prior approval of a visa petition was erroneous, he can exercise his discretion to revoke it. Under Bouarfa's interpretation, the Secretary would be required to do so at any time he determined that the agency made a mistake, no matter the circumstance. Congress, however, left that decision to the Secretary. The agency's mea culpa may, but need not, result in the non-citizen losing his ability to gain permanent residency. Subsection 2. With text and context against her, Bouarfa turns to agency practice. She contends that, as a practical matter, the Secretary always revokes the agency's approval of a visa petition if the agency later makes a sham marriage determination. That may be true. At oral argument, the government was unable to identify a single instance in which the agency declined to revoke its approval after determining that the beneficiary had entered into a sham marriage. But Congress did not make the availability of judicial review dependent on agency practice. Rather, Section 1252A2B2 bars judicial review of decisions made discretionary by legislation. Furthermore, the fact that the agency appears to be exercising its revocation discretion consistently is a virtue, not a vice. Bouarfa's use it or lose it theory of agency discretion creates perverse incentives. encouraging an agency to act arbitrarily by revoking some approvals after a sham marriage finding while maintaining others, or risk losing congressionally granted insulation from judicial review. Nor is it unreasonable, as Bouarfa protests, to suppose that Congress created a system in which a sham marriage determination is reviewable if it is the reason for the agency's denial of a petition, but not if it is the reason for the agency's revocation. That distinction reflects Congress's choice to provide reduced procedural protection for discretionary relief. In the interest of finality, Congress vested the Secretary with the discretion to allow the agency's mistakes to inure to the benefit of the non-citizen. At the same time, Congress did not want this discretion to open up a new source of litigation. The context in which the agency makes the sham marriage determination thus explains the difference in protection afforded. Footnote 5. Bouarfa protests that this creates a loophole through which the agency can insulate itself from judicial review by granting petitions it is supposed to deny and then subsequently revoking its approval. But she points to no evidence suggesting that the agency has done so in this case or any other, nor has she alleged that the agency violated constitutional or procedural requirements when it revoked her petition. We express no view as to whether a lawsuit with such allegations would be reviewable. Subsection 3. Finally, our precedent does not mandate Bouarfa's interpretation. In Patel, we held that Section 1252A2B1 precludes judicial review of factual findings that underlie a denial of discretionary relief, including when those findings are threshold requirements established by Congress to access the relevant discretion. In concluding that Section 1252A2B1 reaches those threshold determinations, we relied on the fact that the provision prohibits judicial review of any judgment regarding the granting of relief under the enumerated provisions. Bouarfa argues that because the jurisdiction stripping provision at issue here lacks similar language, its scope must be narrower. But even assuming that is true, that does not help Bouarfa here, because unlike the discretionary determination at issue in Patel, Section 1155's revocation authorization has no threshold requirements. We therefore need not resolve whether Section 1252A2B2 strips courts of jurisdiction to review threshold determinations that the agency must make before exercising discretion. Bouarfa also leans on the general presumption that administrative action is subject to judicial review. See Guerrero Lasprilla. But that presumption may be overcome by clear and convincing evidence of congressional intent to preclude judicial review. Section 1252A2B2, which is, after all, a jurisdiction-stripping statute, clearly expresses Congress's desire to preclude judicial review of the Secretary's discretionary revocation of an approved visa petition. Because the statute is clear, we have no reason to resort to the presumption of reviewability. In Section 1155, Congress granted the Secretary broad authority to revoke an approved visa petition at any time for what he deems to be good and sufficient cause. Such a revocation is thus in the discretion of the agency. Section 1252A2B2. Where Section 1252A2B2 applies, then, it bars judicial review of the Secretary's revocation under Section 1155. Therefore, we affirm the judgment of the Court of Appeals. It is so ordered. And as the decision was unanimous, there are no dissents to read, there are also no concurrences, so I will just move my thoughts on the case. I don't have all that many thoughts on the case because it seems pretty straightforward and obvious to me, and apparently to the court as well, as evidenced by the fact that it was unanimous and there wasn't even so much as a concurrence to add anything. Yeah, the statutory text is plain, and when the statutory text is plain, you really don't need to go any further. I think most of the court's analysis in this case, or in this opinion, was kind of unnecessary, except just for the purpose of dispelling the different arguments put forward by Bouarfa. Yeah, the text is extremely clear. You know, text is the clearest, most reliable indicator of the meaning of a law, and the text is clear here. Section 1155 plainly grants the secretary very broad discretion with respect to revoking previously granted visa applications. He may do it, so he doesn't even have to. Can do it at any time, and any time that he, or for any reason that he deems provides good and sufficient cause. Like, it's it's hard to get more obviously discretionary than that. And 1252, or section 1252A2B2, clearly precludes judicial review for a wide category of discretionary actions by the agency. So yeah, there's no judicial review here. I don't see any two ways around it. All of the arguments presented by Bouarfa seemed very unconvincing and very easily and quickly dispelled by the court. Again, I think all of the reasoning that was undertaken to dispel those arguments was unnecessary. To reach the conclusion here, they were only necessary because, well, Bouarfa made these arguments, so we have to address them, or at least we should. But I will say, as a practical matter, as a policy matter, I don't like precluding judicial review. Just generally speaking, like I sort of have a presumption, um, or a general preference against precluding judicial review. I prefer that the actions of the government be, subject to more than just political oversight. But that said, Congress definitely has the authority to preclude judicial review. They can make regulations and exceptions to the appellate jurisdiction of the federal judiciary. So they can certainly do this, and they did do it here. Also, as a practical matter, after reading the question presented, I definitely shared Bouarfa's sort of loophole concern that was pointed out in one of the footnotes. But it seems at least that the court is not concerned that this is an issue on the ground, that the agency is actually like granting petitions that it should be denying, and then later coming back and revoking them just to avoid judicial review. I would certainly be worried about that. That seems like a very obvious loophole if the agency wants to avoid judicial review, which, agencies generally, I would think, want to or have an incentive to. But, yeah, it doesn't seem to be a practical issue. And, that would, closing that loophole, even if it were a practical issue, is without a doubt a job for Congress and not for the courts. If statutes are written in such a manner that they enable agencies to sort of abuse them according to what they plainly authorize or plainly allow, the courts don't get to rewrite those statutes. It's unfortunate, but Congress is kind of the only the only recourse there. But yeah, again, it doesn't seem to be an issue on the ground, or at least the court is not concerned that it's an issue on the ground. So, eh. But all of that said, that's about all that I have to say, and I probably rambled quite a lot more than I needed to. I think the court got it right, unanimously so. So, I guess tune in for the next episode. We will continue the trek through the 2024 term. Till then.